How do you get a temporary restraining order, and what is the difference between a temporary restraining order and a permanent restraining order? A temporary restraining order is granted after a non-noticed hearing to the court requesting protection under a 21-day period of time. A temporary restraining order needs to plead exigent circumstances or an emergency, pleading for your protection or the protection of others. This is important because if there hasn't been a recent activity that warrants a restraining order, a temporary restraining order can be denied, but a permanent one could still be granted. So if you're looking for a temporary restraining order, it is important to note that it's important to act quickly in time with regards to when the incident occurred. You don't want to wait it out to see if things actually change, because that can hinder your ability to protect yourself. You want to get the restraining order filed as soon in time to the incident as possible to ensure that you are protected. You will then be granted 21 days of protection until the second hearing, the hearing on the permanent restraining order, exists. At that hearing, you have to prove that there was not only justification for the temporary restraining order to be granted, but that under the circumstances that if you were not granted a permanent restraining order, that there is a likelihood of continued abuse, harassment, or property damage to occur in the future. These areas are extremely important to refer to an attorney's advice, as they're not as easy to get on a permanent basis as they are for a temporary basis. And there are certain things that must be done in between the time that you have a temporary restraining order before the permanent can be granted. It is important that you serve the other party at least 5 days prior to the permanent hearing, or your hearing will be continued for proper service. A permanent restraining order cannot be granted if you do not serve the opposing party with a restraining order request, because it would be against their constitutional rights to not be given notice of the permanent hearing.